Hello everyone, a very warm welcome to all of you. I, Dr. Shakha Dhiman, Assistant Professor, Department of Laws, Guru Nanak Dev University, Amritsar, is here in front of you to deliver a lecture on the topic Racial Discrimination in Judicial System in India. Let's begin with an introduction. I have a dream that one day, right there in Alabama, little black boys and little black girls will be able to join hands with little white boys and white girls as sisters and brothers, as quoted by Martin Luther King Jr. Racism seemed to be a nightmare until it was blatantly bloated in all parts of the world wide web of equality and justice. Discrimination erodes the basic aspect of human morality. The eroding essence of racism has been spreading its redolence in India since its existential history of colonialism and imperialism. Racism is an unethical behavior of one human being against other because of variations in the backdrop, physical appearance, skin color or birthplace. It is the usurpation of an individual's rights and opportunities based on preconceived stereotypes and prejudices. Discrimination based on an ethical or cultural basis is often referred to as racial discrimination. The severity of the discriminatory action and which one is considered insulting is indeed a matter of discussion. Discrimination in the administration of justice, whether in policing, criminal prosecutors, trials, sentencing or imprisonment, can cause extraordinary harm to individuals and society alike and have lasting consequences for future generations, and for the same happened in the case of India. American Anthropological Association defines race as group of persons who are relatively alike in their biological inheritance and are distinct from other groups. It is a cultural phenomenon addressing to a person's identification with the particular cultural group. However, race is socially constructed and the notion was developed on the belief that there was a biological basis for categorizing groups of people. Biologically speaking, the term race has no meaning at all. Yet, society continues to give it the meaning by using it as a social category. It's a social practice that attributes merits or allocates values to members of racially categorized groups solely because of their race. There are at least three aspects to racism: personal prejudice, ideological racism, where culture and biology are used to rationalize and justify the superior position of a dominant culture, and institutional racism, where the policies and practices of institutions operate to produce systematic and continuing differences between racial groups. Racial discrimination in the administration of justice is a global problem which subverts the rule of law, undermines faith in the legal system, and results in victimization of racial and ethnic groups by the very institutions responsible for their protection. Discrimination exists at all levels of the criminal justice system, from racial profiling in the investigation of crimes to disproportionate levels of police mistreatment during apprehension or custody, to the imposition of harsher sentences on members of certain racial or ethnic groups, etc. In a mutually reinforcing cycle, the overrepresentation of minorities as victims and defendants in the criminal justice system undergirds prejudicial attitudes that, left unchecked, perpetuate further discrimination. Now let's talk something about historical roots of this racial discrimination. The racial discrimination can be traced back to India, to the advent of East India Company in India. the discrimination done by the Britishers against the Indians can be classified into three categories. Let's discuss one by one. Discrimination in the jurisdiction of courts. Under the Regulating Act of 1773, the British subjects were given more privilege than the Indians. British-born subjects were exempted from the jurisdiction of the company's courts. The British-born subjects could only be tried by the Crown's Court. Thus, if a British man committed an offence, he could not be charged by the company's court. He was immune to it. He can only be prosecuted in the Crown's Court. Even if a British subject filed a suit in a company's court, which had the jurisdiction with respect to the other party but did not have the jurisdiction over the British subject, then he had to write a bond to be bound by the decision. Otherwise, the decision of the said court would not be binding on the British subject. Most of the British subjects who were merchants and traders residing in Bengal, Bihar and Odisha but beyond Calcutta could recover their claims against the native inhabitants easily by resorting to the local Diwani Adalats. But the Indian inhabitants had no such reciprocal means against the British subjects, against whom the cases could be filed only in the Supreme Court of Calcutta. Discrimination in appointment. The discrimination against Indians can be seen in other ways also. In the scheme of 1793, the highest judicial office that an Indian could occupy was of munsif. Britishers always believed that Indians from their character and bearing were unworthy of holding any position of responsibility and trust, and those they could be employed only in humble positions. The Indians could only act as munsifs to decide civil cases up to ₹50 and as law officers to expound the principles of Hindu and Muslim laws. Next, discrimination in salary, not only in the occupying of posts but also in the payment of salaries. The Indians were always discriminated against. In 1797, when Lord Cornwallis enhanced the remuneration of the British officials, no such benefit was conferred on Indian officials. Then, successive British governments have made use of legal weapons as the basic means of attacking it. They enacted legislations enabling sanctions to be invoked via legal procedures against those found to have committed violations. The system of law courts that administers justice and constitutes the judicial branch of the government is referred to the judicial system of that country. The judicial system in pre-colonial India neither adopted proper procedures nor had proper organization of the law courts. Under the Regulating Act of 1733, British-born subjects were exempted from the jurisdiction of the company's court, highlighting the very early symptoms of the disaster that was about to spread. As a result of this mindset, in the judicial systems of 1790 and 1793, we can see that all the responsible positions were occupied by the British only. Indians were discriminated against the salary and remuneration benefits as well. However, in matters beyond that, they were only subjected only to the jurisdiction of the Supreme Court of Calcutta. This privileges was not available to Indians. A proper judicial system in India was established in 1950, where the Supreme Court had the jurisdiction and was elevated to the highest court in the legal system in India. With the period of modernization, along with changing trends, the judicial system became increasingly complicated and costly. There was plenty of room for deception and anarchy. Now let's talk about the prevalent scenario of racial discrimination in India. Racism has been institutionalized. In India, the population is dependent on the structures that surround them. These structures provide them multiple opportunities and fundamental rights. Institutionalized racism is a type of racism that is reserved or unethical and is practiced by a political or social organization. This type of racism is most often seen when an institution's management is biased and prejudiced towards people who are different. It can also happen when organizations knowingly limit and refuse to respect the rights of a particular group of people. Discrimination of this kind can be found in educational schools, healthcare facilities, and other workplaces. Preconceptions and racism based on gender are most prevalent in the workplace, which is referred to as systematic racism. It also makes people less efficient by disincentivizing them from functioning. Such prejudice causes a particularly negative effect, leading to depression in majority of the instances. Because of their structural strength, people in dominant positions often discriminate against subordinates. It is a largely overlooked form of racism in society, and it persists in even the most modern societies. Regulation through legal mechanisms is also a process of which our understanding seems to be surprisingly sparse. The imposition of rule emanating from some organ of the state, including the judiciary, which requires individuals to act in a manner different from how they would have liked to act in a certain way without fear of adverse consequences that otherwise would have existed. Indirect discrimination results into making of policies or practices which are not racist in intent. Both have disproportionate adverse effects upon racial minority. Now, what can be the reason of that? The reason law cannot extend to racial disadvantage is that no one is formally liable. Discrimination is both a major element and a continuing long-term cause of disadvantage, but the latter has a self-perpetuating dynamic or its own, and both extends much wider and is product of several additional and even less tangible influences. In the judicial systems, individual voices are heard, whereas individualized decision making is the opponent of prejudice. A person's forced membership in a group causes him to be mistreated or put in certain social situations. It has a collective component that is challenging to accommodate within the established legal procedures. It's a complex issue, and India's social dynamics involve caste-based discrimination rather than racial discrimination in the Western sense. The Indian judicial system addresses issues related to caste and ethnicity. Though certain communities, especially those belonging to scheduled castes and scheduled tribes, have faced discrimination and continue to face. Despite constitutional safeguards, the members of judicial system in India experience bias in various facets of the judicial process, including police investigations, courtroom proceedings, appointments, litigation, sentencing, and in fact in academia as well. India's legal landscape is multifaceted, and efforts are being made to address these disparities. Racial discrimination in the judicial system in India is a complex issue, with various factors contributing to disparities. It results into instances of racial profiling by law enforcement, can lead to biased arrest and investigations, disproportionately affecting certain communities. Economic disparities result in unequal access to quality legal representation, affecting the ability of marginalized communities to defend their rights effectively. Stereotypes and prejudice can influence judicial decisions, affecting outcomes for individuals from specific racial or ethnic backgrounds. Some people argue that bias may exist among certain judges, impacting their decisions in ways that perpetuate racial disparities. Judiciary can contribute to a lack of understanding and empathy for the challenges faced by marginalized groups. Outdated or discriminatory laws may disproportionately impact specific communities, exacerbating disparities within the judicial system. Sensitivity to cultural nuances is crucial for fair legal proceedings, and the absence of such understanding can definitely lead to discriminatory outcomes. Now let's talk something about legislative and constitutional framework to combat this racial discrimination in India. The preamble of Indian Constitution seeks to secure justice, social, economic and political, which ensures equality and liberty. Article 14 of the Indian Constitution envisages right to equality and equal protection of law. It states that the state shall ensure equality before laws and equal protection of laws within the territory of India. Further, Article 15 prohibits discrimination on the basis of race, caste, sex, place of birth and religion. In addition to this, Article 15 Clause 3 provides that special provision can be made for children and women in ensuring equal justice. Another provision, Article 16, gives impetus to the protection of the economic interests of the persons residing in India in the matters of public employment. Then, Article 17 provides for the abolition of untouchability. Untouchability is the practice that gives rise to racial and caste discrimination. Anyone who engages in the practice of untouchability gives rise to legal consequences. Further, we have Article 21 that ensures that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Living with the human dignity is a part and parcel of the fundamental right of life guaranteed under Article 21. Then we have some provisions in the Directive Principles of State Policy. Article 39A of the Constitution envisages right to equal justice and free legal aid. Article 46 of the Constitution of India guarantees that the weaker sections of the society, such as the scheduled castes and the scheduled tribes, are protected and that special arrangement is made to meet their economic and educational needs. Further, Article 51A, Clause E states that every citizen has a responsibility to promote a sense of unity and harmony among all Indian people and also to denounce practices that are disrespectful to women's dignity. Various legislations in this regard have been introduced to remove the racial discrimination in general. Talking about the criminal law, Section 153A of the Indian Penal Code criminalizes the use of the language that promotes discrimination or violence against people on the basis of race, caste, sex, place of birth, religion, gender identity, sexual orientation or any other category. The offence is cognizable and the penalty can be imposed up to 3 years or fine or both. The penalty for crime perpetrated in a place of worship is increased to 5 years and fine. In addition to this, we have Anti-Discrimination and Equality Bill 2016, which was introduced by MP Shashi Tharoor. It is a comprehensive anti-discrimination law which would go a long way in fostering diversity and pluralism in Indian society. The bill significantly broadens the categories of what will be regarded as discrimination and prejudicial treatment under the law. Direct and indirect differentiation, badgering, isolation, biased violence and abuse are all addressed in this bill. It provides for compensation to be paid by those engaging in discriminatory, segregation or boycott practices. The amount for damage is twice the monthly salary of a member of parliament or rupees 1 lakh, whichever is higher, and for aggravated discrimination, exemplary damages can be awarded. It also provides for protective orders, which are a type of restraining orders to prevent an individual or organization from continuing to carry out discriminatory act or even practice. Apart from that, we have the Caste Disabilities Removal Act 1850, which grants the citizen the freedom and equal rights to convert their religion. Their rights, specifically their inheritance, will not be revoked if they converted their faith. This act ensured that the people will not be subjected to discrimination on the basis that they belong to a particular caste. In addition to this, we have the Prevention of Atrocities Act, Scheduled Castes and Scheduled Tribes Act 1989, which was introduced. This legislation safeguards the rights of SCs and STs against discrimination and exploitation. It shields the weaker sections of society from violence, cruelty, brutality and ruthless terror. Section 14 of the SC/ST Act establishes speedy trial and courts to ensure that OBC and other tribal peoples receive prompt justice and are not left defenseless. For offences committed under the Act, there is no option for anticipatory bail. Many legislations and constitutional provisions have been integrated to ensure equality and justice. But it is disheartening to witness that despite of constitutional protection, members of judicial system of India, whether from bar or bench or litigants or legal academia, have to undergo discrimination and emotional trauma. Now let's talk something about judicial interpretation. Recently, Honorable Supreme Court of India has released the Handbook on Gender Stereotypes with an intention of assisting judges and legal practitioners in recognizing, understanding and combating gender stereotypes present in legal language and judgments. It highlights common stereotypical words and phrases that are often used to describe women in legal documents. It specifies instances where usage of such language perpetuates antiquated or incorrect notions about women's roles and behaviors. It also provides a list of neutral and accurate terms. There is a dire need for introducing similar handbook for combating the racial discrimination in India. The court, in the various cases, remarked that the discrimination in law enforcement and the justice system can be a primary factor in preserving or promoting economic, social and political inequities founded in broader discriminatory state and private practices. In a vicious circle of society, racial or descent-based economic, social and political marginalization generates discrimination in the action of police and the judicial system, deepening social divisions and increasing that marginalization. At the national or local level, discrimination can arise from the practices with racist intent like racial profiling, in which an individual's presumed race is the determining factor in placing them under suspicion. The mechanisms for criminal justice can equally result in unjustified discriminatory effect where there is no clear racist intent. Discriminatory impact can be shown in patterns of police abuse, arbitrary arrest, incarceration, prosecution and sentencing. The de facto denial of remedies to a particular groups within a criminal justice system may be evidence of unjustified racial discrimination regardless of the intent of the lawmakers and public officials. That was mainly about the racial discrimination. Now let's come to the concluding part and few suggestive measures. For 20 years, governments have contented themselves with enacting legislation, creating individual rights, and imposing limited negative requirements on private employers. It is impossible to say whether the preference for a legal approach was based upon an exaggerated faith in the efficacy of law or the need for political reasons to be seen to do something highly visible, such as enacting a statute, or was a conscious alternative to taking on a wider long-term expensive and controversial commitment that continued reliance on the legal approach in the future will signal a decision that racial equality has been accorded. Addressing these issues requires comprehensive efforts, including legal reforms, increased diversity in the legal system, awareness campaigns, and initiatives to combat this biasness. Even in the modern times, when progress is at its peak, some orthodox and traditional ideas still remains the same. Racism is a threat to society that is not external but mental, and it is present in everyone's life. Since racism is so common, both the perpetrator and the victim often overlook and dismiss instances of racism. It is necessary to shift people's perceptions and stereotypes of people towards the race and culture. That's all for the lecture. Thank you everyone for your time and attention. We have covered almost the entire concept in a short time, and I hope that the listeners have enjoyed and understood the topic. Stay safe, stay healthy. God bless you all. Take care.